Good afternoon, everyone. This is Stephanie Garces-Stoney, owner of Garces Law. Thank you for tuning in to the Pink Maggie Confessions. We have a good topic this week, kind of similar to the last week's episode, but a little bit more in depth. I really hope you guys learn a little bit more today about the difficulties that we talk about when we're talking about like us adults, some of our parents, some of the difficulties they face as they're aging, and things start to change, and they don't have any basic estate plan in order. What happens to them? Why is it critical? And really, in the event your parents don't have anything, why they should consider it, especially when they can't take care of themselves, which unfortunately some happens to some of us at some point in our lives. But I want to thank everyone for watching today. As you know, I'm Stephanie Garces-Stoney, the owner of Garces Law Firm, where we help parents secure their legacy. And actually now we're helping adult children secure their legacy by helping their parents as well. So always here to help. Like I mentioned, today's topic, I'm going to be talking about what happens when the roles of us as children or adult children changes into having to be sort of like parents to our own parents. This does happen sometimes, and sometimes people don't know what to do. So that's what we're going to talk about today. Now, most people will go through a period in their life where they need to care for their parents. They don't really know where to turn, and during this time, the planning and the documents that need to be put in place are really critical to the outcome and to your goals. You obviously have to do this while you're able to do it and mom and dad are still well. And we'll talk about that in detail, but you certainly don't want to wait on these things. It makes a huge difference when you have someone helping you, especially an attorney like myself, who does this every day and really knows the ins and outs of the law, what's required to do the next thing. And so these things really do matter. So I really hope you learned something today. Keep in mind that if no planning is done in general, there are consequences for you and your family, and it can make life incredibly difficult. So we want to avoid all that. So as I mentioned, today's topic was actually requested by some audience members whose parents have not adequately planned for a unforeseen incident. For example, if they lose capacity, or if they have a impairment that happened overnight. Also, we talk a lot about people that haven't planned for retirement. I am no financial advisor, but this does matter, as far as having estate planning documents in order for your finances. So some are now facing health issues. As you know, we are in the middle of a pandemic. Of all times, this is so important. So I really hope that, people understand that there is help. Us children with our parents have to sort of decide things and make moves while we can. And always trying to make sure that we're taking care of our family. And so sometimes that responsibility gets shifted at some point. So sometimes we have to do things like speak to doctors, or perhaps we have to get involved with the property that our parents own. Maybe it's more than one property, or their cars, or their assets, their checking accounts. Sometimes people will have money tied up in different types of accounts. And so we end up having to make decisions for our parents when something happens. So situations like these are all too common and can happen very unexpectedly. So today, just to give you kind of the scenarios we're going to run through, we're going to talk about what a power of attorney is for healthcare. What do you need to be able to speak to doctors, make medical decisions on behalf of your family members? We're also going to talk about durable power of attorneys for financial. That is basically separate. It's a separate type of power of attorney document that you'll want to hear about today. And also, we're going to cover living wills. What's the difference between a will and a living will for aging parents, or even for yourself? I mean, these things are not something that we need to put off personally, but sometimes our parents don't have it. So I know that's focus of today, so I wanted to mention that. But another thing that pops up, by the way, is a transfer of property. Super, super common. If parents have not saved enough for retirement, what happens to the property if they want to transfer the assets to someone else, or perhaps they want to prevent those assets from being seized? A lot of times people will have questions about like Medicare. Or perhaps they're in a retirement home. What happens to the property then? Those things do matter. There's so many things we can talk about for that. But those are some of the topics that we get asked about. And lastly, we're going to talk about how do you speak to your parent about getting these documents in order, especially when they're resistant, they're what's considered old school. They say, oh, I don't need that. That's a waste, or we'll get it online. And we'll talk about the online thing because people love asking me about that. And I love talking about it. So I'll tell you the difference between getting something online and getting something from an attorney that actually is licensed to practice law in the state that you live in. So all of that stuff matters. And we're going to jump right in. So just to recap again, like I said, my name is Attorney Stephanie Garces-Donay. I'm the owner of Garces Law in Arlington Heights. We help parents secure their legacy and plan for life's transitions, including protecting your children if something happens to you. And this also includes adult children, by the way. So like I said, today we're talking about why estate planning cannot wait. I get calls all the time of people that say, I really, really want to do my estate plan. And then we go through the options and they want to say, okay, well, I'm going to do it next year. And I'm going to tell you why you don't have to wait and you shouldn't wait. So we'll talk about that today. Like I always mention, I wanted to tune in really quick and say last week we had a really good episode about what are the top 10 questions about estate planning that I get. And you can check my answers on our YouTube channel or Facebook Live. That's on my page, on my Facebook page. Feel free to check that out. It's free. It's free. It's all really important information. And certainly check it out if you haven't already. So we welcome you to join us here on Tuesdays at 1:00 to discuss some of the questions you guys have about legal stuff, estate planning. We also talk about some other things, and I'm always open to hearing what the audience has to say. So we're going to dive right in. One of the questions that we get a lot is what happens if the state gets involved because we didn't get a power of attorney? Now, this is a loaded question because when we talk about the state, we're really talking about a proceeding. A judge usually or a court has to get involved to appoint what's called a guardian to take over another person who's 18 years or older and cannot make basic decisions for themselves. And this includes they can't manage their property, their finances. Perhaps they're having issues mentally, physically. This really can be a loot of things, but really when we're talking about capacity, that is a term in the legal world, or I should say the medical world, not the legal world. Well, we use it in legal too, but in the medical world, capacity really includes someone being able to make decisions and especially about their healthcare. That's a big one. So when we talk about impairments and what are things that people would want to have in place, powers of attorney are very important. Really, the reason is, and we'll dive into a little bit later, is that it actually sets something up so that someone can actually step into your shoes and help you make decisions when you can no longer make them yourself. Now, when I talked about someone who maybe lacks capacity, this is someone that maybe has a mental illness, someone who has a developmental disability. It could be physical impairment, and the list goes on. So it could be a number of things, but that's just something to keep in mind. So what happens if the court gets involved? Well, you have to actually open a proceeding, and you do have to hire an attorney to help you with that. So that is not something that you want to try to do. You want to avoid it if you can. But obviously people end up there. So it's definitely something that people will want to try to avoid. So we'll talk about how to avoid going to court and certain things. Hopefully that is something that you're interested in, so you can keep watching. Another question that I get is, why is the probate process so expensive? This is a very important question because people will sometimes ask, why is it that probate is where you end up and why is it so pricey? Well, besides the fact that this is a system that's really designed to ensure that the estate is taken care of, that the right people get the right things from the estate, usually you end up there because there's either no estate planning in place in general, and someone could have only the house and that's their biggest asset, and they could still end up in probate. The alternative is true, where someone could also have many properties, maybe one property and a lot of assets, and they don't have any sort of estate planning documents to transfer those assets. That actually does impact your likelihood of going to probate. The reason it's expensive is because there is a lot involved. Usually the court in itself charges you to go to probate. Those are called court costs. Of course, you have to pay the attorneys, which we also are going to charge for our time. There's also other things. For example, we talk a lot about probate and the purpose of it. Well, it's also designed to allow creditors to file a claim. So sometimes the person that has passed away owes money to somebody. This could be any creditor. Let's just say it's a credit card. A credit card company files a claim. They say, you know what, Uncle Sam had a claim with us because he took out a $20,000 credit line and basically he never paid us because he passed away. So a creditor, which is the credit card company, they actually do get to go to court and see if they could get paid before the heirs get paid. And so this really is a safeguard that protects creditors, but also future heirs involved in the process. But the point is that there's a lot of court filings, there's court oversight, there's a lot of notices and filings, notifications that have to go out. There's also a bond. I haven't talked too much about this, but sometimes a bond is required, which is basically required when someone doesn't have a will in place and passes away and has to go to probate. At minimum, it's at least $1,000. So it could be as much as triple that. 300,000, something crazy. I mean, it really is just depends on the estate. But the point I'm trying to make is that it's expensive because there's just a lot involved. And of course, it takes a long time. So really, between court costs and fees and attorney's fees and everything in between, it gets expensive. You also have to consider too, in probate, sometimes the heirs are not in agreement. There's a number of family members that'll call us saying they are in a fight with their sibling because of the estate and they want to get this and mom was going to leave me that. And so that does arise, and those disputes do lead to more expensive probate estates. So just something to keep in mind why probate is so expensive. Now, how can I avoid probate and state involvement? Now that I've sort of told you about how expensive it is and time consuming it is, the most basic way to avoid probate or having your family even have to go there is to get estate planning documents in order. I repeat, get your estate planning documents in order. Some viewers will ask me all the time, how quickly can I do this? When should I do it? I'm single. I don't have kids. Should I be putting something in order? Absolutely. It doesn't matter if you have not a lot or an abundance of assets. The reason you want to put something in order is because if something happens to you, your family and your loved ones who outlive you would not have to go into probate. As you know, it's expensive, it's time consuming, it's not somewhere that is where anybody really intends to be, but it's certainly necessary for some individuals that don't have that in order. So estate planning documents and getting the proper attorney to kind of guide you through the process is really the way to avoid probate. Now, if you download documents online, I know questions like that will come in. Can I just download them online? Can I just pay a service to come to my house to basically give me the documents and I just sign? Or maybe I do it a la carte and I, buy it online and then I get them done myself. Well, of course you could do that. If you were to Google, even before this video, I had actually Googled online forms, and there are so many out there. Now, I'm not telling you that it's not possible, but what I'm telling you is that it's definitely not customized to your needs. And that is really the difference between just doing it online and going with an attorney. So something to keep in mind, because you don't necessarily want to be doing things on your own, because again, there are just so many implications that come when you don't get the proper documents set up. And trust me when I tell you, I know people are on a budget. I know that people want to save. And this is something that, us at our firm, we can certainly help you with payments. We have different alternatives of payments. It's very feasible. So don't ever feel like it isn't. If you have questions about that, you can always call and text, and we'll talk you through some of the options that we offer. But like I said, getting it online, yes, you might save the money, you might save the trip to the attorney's office, but it's not customized and it doesn't necessarily work because you could really run into an issue where the documents are not recognized, meaning they're not valid. So these are things that you don't want to put yourself in or your family in, all because you decided to just get them online. Also, keep in mind, some of these online platforms do not customize to the state. So you might download something online that you found just Googling, but to make it legal and valid, every state is different. So there are proper requirements, Illinois requirements, to make sure that if something does happen to you, that will is recognized, it's valid, and it upholds in court, or just upholds in general. And so these are the reasons why downloading them and doing your free online forms, or even at minimal cost, is not worth it, because you will end up paying for it at the end. And so will your family, unfortunately. So just something to keep in mind. But I do get a lot of questions about that. Now, another thing that is asked often is HIPAA. HIPAA release forms. Are these the same as healthcare power of attorneys? While they're very different documents, although the one thing they have in common is they have to do with medical records and decisions, but in fact, they're very different. So, for example, the HIPAA authorization is really a consent form. We actually prepare these for our clients, and it would allow a patient to have their records released to the person that they've chosen. Typically, HIPAA, it's a privacy rule. It's a law that says no one can have their medical records disclosed without consent. So the HIPAA authorization is something that we offer. It's super important for an estate plan to have it, because if you don't have it, you actually don't have the ability to actually have someone who you appointed to have access to your records in the event you can't consent to it while you're incapacitated or unable to make your decisions. And these are really powerful documents, because the person that doesn't have it, well, HIPAA would forbid anyone from seeing your records. And so that really is very different than the power of attorney for healthcare. The power of attorney for healthcare is a little bit different in that it actually appoints someone to make decisions on your behalf. So that means if you became incapacitated, if you are on life support, who's the person making medical decisions on your behalf? This person steps into your shoes and basically makes the medical decisions for you. So typically, physicians, hospitals will want to see a legal power of attorney for healthcare. If there's anyone, wife, kids, anyone in your family that would actually make decisions for you, if you cannot make them yourselves for your medical affairs. And that is really the stark difference between a power of attorney for healthcare and HIPAA authorization. Now, there are a couple other questions I get about that, kind of going in more into the weeds here, is what is the difference between a healthcare power of attorney and a healthcare directive? Again, a little bit more similar, but still very different. You already heard that the healthcare power of attorney gives authority to another person to really act on your behalf for any health matters, medical decisions. This person has a lot of power, and they actually need to have capacity themselves. So the person that you choose has to be someone you trust, has to be someone who's able to actually be present and really just make important decisions for you. So if you're ever considering doing that, you have to do it while you're living, of course. You have to have capacity, and we'll talk about a little bit more about that later. But the point is that you certainly want to pick somebody to make decisions on your behalf, because everyone should have one. Everyone 18 or older should have one. These are very important documents because, again, when the time comes, God forbid, there were something to happen, you actually have the proper documentation to protect you, for someone to make decisions for you, and it's someone that you chose. So that is kind of the reason why the power of attorney is something that a lot of people consider, and we usually make it part of your standard estate plan if you don't have one in order. And of course, if you're interested, we do offer those all by themselves if you already have an estate plan and want to supplement, or if you have a power of attorney and you want to amend it or change the person that you've picked, we can help you do that as well. Now, I told you I would tell you what the directive means. Well, the healthcare directive, actually, the word directive is basically directing somebody, someone that you've chosen, to basically make decisions about whether you would want to be kept alive, whether that's by artificial means or if you are terminally ill or permanently incapacitated, whether or not you would allow other type of treatment to keep you alive, but wouldn't cure you. These are what healthcare directives are. They basically designate someone to make those decisions if you cannot. So it's a little bit more specific and it's a little bit more serious, but it basically steers the person that you've picked in the direction that you actually wanted if you were in that position. So these are very important documents as well because it gives power to you if you were incapacitated because you've already chosen somebody and you've given them instructions on what you want. And so this sort of thing is very important because it actually lets someone know, hey, when I was conscious and I was making these decisions, this is what I really wanted. And so that's what a healthcare directive does. Very important, very necessary to have in the estate plan. Now, sometimes we have a question that is actually pretty concerning for some people because they don't know what they should do about their parent. Sometimes people will ask, what should I do if I first suspect my parent or relative is not being truthful about their medical condition? Or perhaps I suspect that something is wrong with them medically. Now, I know we all have parents that maybe don't want to tell us what the truth is because they want to protect us. That makes sense. Plenty of parents do that. But let's just say you're wondering, what can I do? What are my options? Well, you can always get a medical evaluation by a licensed physician. Many people will think about this as a, thing that, wow, I don't know if mom or dad would like that. But sometimes it's necessary, especially if you aren't sure. Keep in mind that when you enter into estate planning documents, the person, your parent, who's going to be signing the documents has to be of sound mind, which in the legal world means they can make decisions for themselves. They're competent, they understand, they know how to enter into these documents, and they have capacity. So I throw this word around a lot, but really that is the medical term for it. And that is what we strive for because we want to make sure that the person that is working with us is fully aware that we represent them, they understand what we're doing, and they are cognizant and can recognize and have competency in the documents that they're signing and that they know that the decisions they're making are ones of their own. So medical evaluations are very important. A formal assessment can be done to evaluate capacity. And it's sometimes even a consultation with a psychiatrist is also something that people do. That is not unheard of, and in some cases is necessary. So very helpful to try to think about these things as options, and they're always available to you if you are in a position where you think that would benefit your parent. Now, if you're concerned about your parents' well-being, especially their mental health, if it's failing, you can always talk to your local physician. If you don't have one, you can certainly look, with your insurance. Sometimes there's even places that take people without insurance at like a fixed fee. So there's different options for people that may or may not have the means to go to the doctor, or perhaps they're looking for something a little more cost efficient. So just keep that in mind. But kind of going into the documents, one of the questions I get a lot is, what are the most important documents to have in my estate plan? Now, I've mentioned a ton of them because there are so many documents that you can add. But at the very least, to help your parents, one of the things you should certainly consider is, as I mentioned already, the powers of attorney. For healthcare, the powers of attorney for financial. The financial power of attorney, by the way, that does allow the person that your parent has chosen, whether it's you or your sibling or someone else, to really make financial decisions for them in case they can't make them themselves. A living will, very important. For the reasons I mentioned, you get to actually direct in how you want to be treated in the event you are on life support or in a position where you are not going to recover. That gives direction to the person that you've chosen to make sure that they know what you wanted. The HIPAA authorization is also very important for the reasons I mentioned earlier. You certainly want to have that in order to make sure that the person that you've chosen to make medical decisions has access to those records and can get them if they needed them. Another thing that's really important is just a will, a basic will. And I say basic very lightly because I think everyone, no matter your income, your background, what you have or don't have, children or no children, should always consider a will because at the very least, it leaves written instructions in how you wanted your assets splits, who's going to be in charge of your affairs if something happens to you. There are so many reasons why a will is really, really important. Now, there are a couple of documents too. I've talked a lot about trust before. Those are necessary for people of a certain asset category. But I would say, the person that you're thinking of or yourself, if you at least own real estate that's over 100,000, or you yourself have in savings in your house is over 100,000, then yes, a trust could be a good option for your parent or for yourself. Parents, especially most of them at this point in their lives, they either have assets or retirements to protect. So a trust might be a good option. In the alternative, if they are not qualified to have something like that, then we scale it back and we still get an estate plan in order, perhaps a will based estate plan that would actually cover the assets that they have in place. So, nonetheless, there are so many important documents that your parents should have in order, and you should never be afraid to call us to ask about what you think is something that they would want. And remember, we always customize to the client. So everyone is different. We always make sure that the documents that we use are customized to the individual themselves. Now, I think that's all the questions I have, but I don't know if off the top of my head I could think about something else that people ask. One of the main things that someone mentioned to me earlier was, how do I get my mom or dad to sort of make an appointment with you? What is the process? That is a really great question. I love answering this because it kind of gives me an opportunity to show how we do things here. Um, Obviously, you've seen it on the screen. We are available for any free consultations, 30 minutes. With myself, you can text or you can call to book it. You can also go on my website. We do have people available to take your questions or set up a meeting, and we do that at your convenience. You can do it by coming in person if you're comfortable with that. We do wear masks. I have my mask right here. If you're not comfortable with that, or mom and dad cannot come to the office for personal reasons, we can also do videos virtually or meetings virtually. So Google Meets, Zoom. Nowadays, I think everyone is kind of used to that. So we do offer those options as well. And really, the process and the goal during the consultations for me to understand what you're looking to do, how many assets you have, and what we can do to actually customize it based off your needs. Sometimes people will come and say, well, I think I need this. And I might agree with that, but we may want to supplement it with more because you may actually have more than you think, or perhaps there's nothing to protect it. So the process is actually not super complicated, but it does require us to sit down and examine your situation so that we can make sure the documents are tailored to you. And then once the documents are ready and we work together to make sure that it's the proper estate plan for you, we basically have you come and sign here at the office. We have the witnesses, we have the notaries, we have everything that you need to finalize the documents. And that really is the final step. Now, there's a couple other things that we tend to check in on after we make the estate plan, which is a conversation for another day. But what it really is we want to make sure that all the assets are transferred into the trust. And that's a whole nother process in itself. It's also a service that we offer, and we make sure to make that customizable to you as well. So that really is the process for working with us. And I do welcome the opportunity to be able to work with you and your family. So I want to thank all of the viewers today for tuning in to Pink Mike Legal Confessions. It's always an honor to be able to use my platform to inform all of you about what we do and how we can help. And feel free to reach out to me personally or my staff to make sure we can actually set something up for you and your family in the event you don't have anything or are looking to update it. We do both of those. So I encourage you to meet us here on Tuesdays at 1 o'clock to see what else we're talking about. We have some interesting topics coming up, and you will want to stay tuned. So thank you again for your time, and I'll see you guys.